So we're going to hear now, I think, a very different perspective, I suspect, and it's going to be Colby's perspective now, representing victims who allege sexual misconduct or campus rape.
Mm-hmm. Just like compose myself. So I think that in trying to prepare the remarks, I was kind of struggling to convey that I am not, although I am a victim's attorney, I am not an attorney that turns a blind eye to the problems in the process. I think that Brett did a really good job of explaining, that I think a lot of college administrators and colleges are feeling somewhat underwater with a lot new regulations and rules and regulations and guidances and getting different types of consultation from 3 or 4 different attorneys trying to figure it out, trying to make heads or tails. And the reality is those attorneys don't know either. So I think that where I come in, though, is I'm not just sitting by watching. I am talking to these schools. I am going in there and making sure that schools understand what fairness is, because that is the fundamental perspective of what Title IX ought to be. Title IX recognizes that gender-based violence is a cause and a consequence of gender inequity, and that anything short of that fundamental fairness is a violation of federal law. So whether or not you are an accused student or you are an accuser, Title IX requires fundamental fairness. And what I always say to people is, let me be very clear, it benefits no one for an administrator to be unfair to either party. It doesn't benefit the school, it doesn't benefit the victim, and it doesn't benefit the accused. What happens is prolonged appeals, provost's involvement when they weren't supposed to be involved, presidents overturning decisions that nowhere in the policy does it say you can overturn a decision. It really sort of, the problem is on both sides. And so I really stick by very closely to an approach that tries to approach it as fair. That said, I am certainly on a particular side of it. I have been representing victims for over a decade now. I happened into it because I was a pro bono attorney at a law firm who had me marked as a bankruptcy attorney, and they couldn't have been more wrong. And I started to do a lot of pro bono work because I wasn't really intrigued and enthusiastic about the material that I was representing people on. And so I did a lot of pro bono work, and that's how I kind of happened into this. But I think that for me, fairness is the end game that I'm talking about, because again, it doesn't benefit my clients who are survivors of rape and sexual assault to be unfair and for a college to unfairly execute a policy or unfairly implement a policy. I once heard of a school 6 years ago now, and they marched an accused student in. He was accused of raping another student, and they summarily dismissed him and bought him a ticket back to the West Coast. And that was unique because that was 6 years ago, and stuff like that didn't happen 6 years ago. Stuff like that would happen to victims night and day 6 years ago, but not to people who were accused of it. But nevertheless, I was really offended when people thought that I would be in support of that, because it was a big violation of Title IX, and I knew it, and everybody else knew it, and it wasn't fair. This individual person, may or may not have had a college career ahead of him, but was summarily dismissed. And so for me, it's undeserving. It's a violation of the federal law. And I think by the same token, no one deserves to be forced out of a college or a university and thrown off their educational trajectory simply because their perpetrator brings in a lot of revenue for a school as a, Division I athlete, because that's not fair. And that's a violation of Title IX. And any kind of special circumstances or special favors that you want to give to someone who is accused simply because they have a strong track record of putting a school on the map because of something, whether it's an academic decathlon or athletic or fraternities, anything like that, it's just wrong. To help you step into my shoes, I want to just take a moment and read you an excerpt from a memoir of someone who I think, she grew up in Danvers, Massachusetts, and her memoir is called With or Without You. And she says, "The only problem is that I don't sleep much, and when I do, I have horrible nightmares. Some mornings it's hard to shake them off. They cling to my eyes like a gluey caul. A succession of these restless nights makes me loopy and paranoid, afraid of the sounds coming in the air vents in my bedroom, afraid of the car pulling up outside. Who is it? I lean against the door and listen. My neighbor and his son are coming home. I need to take a shower, but I'm afraid to take my clothes off. Even with the door double bolted, the windows locked, and the shades drawn, it feels just too dangerous. For the next 3 days in a row, my only objective is take a shower. Enormous parts of my day are lost inside one memory or another, and certain scenes replay themselves, and I don't know how to make them stop. Sometimes I get so deeply possessed that I forget where I am, and I look up to see to my surprise, and I'm on the number 7 bus, but I've missed my stop. It was miles ago, and now I have no idea where I am. And what if I lose my life like this?" And for me, it doesn't matter if you were stone cold sober and were jumped by someone out of a bush, intoxicated or incapacitated. Hers is the story of every victim of rape and sexual assault. Watching the minutes and the hours and sometimes the days slip by without any control over it. Wondering why this happened to you, wondering if you could have prevented it, blaming yourself for something that you had no control over. But even more frightening to that person is knowing that when you step out of your dorm room, you could run into the person who you believe raped you. And in a heartbeat, you become a recluse. You stop eating, you stop going to class, you stop socializing, you start harming yourself, and eventually you drop out of school. Educational harms, health consequences, and economic costs are the realities of sexual violence. And the Title IX process seeks to redress that because they ensure that victims have options other than dropping out, and options other than shutting themselves out, and opportunities to get support, and even, in some cases, justice. So for me, what does fairness look like? And for me, fairness isn't complex, but these cases definitely are. Fairness is not necessarily the literal meaning of equal. If a victim asks to be shielded by a screen during the hearing so she cannot see the person who raped her, no one would suggest that the accused have a screen equal in size and shape to that of the victim. That would be equal, but certainly both parties should be in a position of comfort, without intimidation, have access to evidence, without a power imbalance. And in my mind, that's fair, but maybe not necessarily the literal definition of equal. Fairness also requires a clean slate, an unbiased arbiter or arbiters, the opportunity to tell your story and be heard. The best way a school can achieve that type of fairness for both parties is to ensure that decision makers and the people who have contact with both parties have training. Basic training on reviewing documents, listening to people, tell what they saw and what they heard and what they felt without judgment. You know, in the earlier days of the Victim Rights Law Center, our organization was unsuccessful in almost every single case that we ever had at a college campus. The facts were on our side, 100%. the law was on our side because we had a 1997 guidance and a 2001 guidance from the Department of Education that said very similar things to the Dear Colleague letter. So I think that all of you can appreciate how unusual it is to have both the facts and the law on your side. And we had all of them. But what existed in that time was an insurmountable hurdle that no one could overcome. And the hurdle was simple. It was bias against the victim and bias in favor of the accused. It was the victim must be lying. The victim must just regret what happened. The victim was drunk and, and just woke up the next day and, just said that wasn't right. Or 3 months later decided that somehow that wasn't right. I don't think that you can impregnate a victim with the idea that he or she was raped. Sometimes you have a fair amount of denial that goes along with being raped and saying, I really don't want to be identified as a rape victim. I don't want the rest of my college career to be identified as a rape victim. And so therefore, maybe it takes me a little bit more time to truly understand the gravity of what happened to me. But we live in a time where awareness has been raised and victims feel safe enough to 3 months later come forward and report that a rape did happen that night. And that there was no discovery 3 months later. It was something that the person knew that night, but had to live with for a little while because didn't want to come out and suggest and maybe falsely accuse someone or whatever, had to be certain about what the allegations were going to be. I remember one of my cases, it was, again, facts and law on our side, and the school said that the student, I wish I had the letter because I wish I could read it to you, but I remember it as clear as I remember today. The student was found not responsible, but the letter said that the student engaged in conduct that was unbecoming of a student of the college. But nevertheless, no punishment was going to be rendered. So we had nowhere to go but up from this. We had nowhere to go but receive more guidance from OCR. We had nowhere to go but get more fairness. I love when people bring cases, on behalf of the accused for unfairness, because what I always say is, where were you 11 years ago when we were in the trenches trying to figure out what fairness looked like for victims? Because it wasn't fair to victims. And so that's why I have made it certainly my mission to ensure that colleges understand what fairness looks like, because I've been on the other side of what fairness doesn't look like. So I think that for me, I just want to challenge the belief that more people are being punished for violations of the code of conduct. And I want to challenge the fact that people automatically assume that that's because it was unfair.
So Colby, but,
Mhm.
two sort of, Justin mentioned sort of representation, for example. Justin mentioned in many universities, the absence of counsel or legal counsel in proceedings where, a victim is alleging sex abuse or sex misconduct against an accused. What's your view on sort of the fairness of either allowing or not allowing representation? And related to that, the issue of burden of proof, where it is by a preponderance of the evidence, and some people have argued that a finding of responsibility in these types of cases is the equivalent of a functional equivalent, without obviously punishment being imprisonment, but carrying that sort of the stigma of being a rapist or of being an attacker. So specifically on the question of burden of proof and representation, do you think that accused should have the appropriate burden of proof is by a preponderance of the evidence, and do you think that representation would make the process more or less fair?
So I absolutely believe that the preponderance of the evidence is the correct standard. I believe it because Title IX, Title VI, and Title VII all have it. It's a civil rights statute, and so preponderance of the evidence is the one that holds for every single one of those statutes as it should for Title IX. As far as the representation piece, what Justin is talking about isn't exclusive to accused students. So oftentimes, the victim's attorney has the same exact requirements that an accused attorney has. So me, I walk in there and I am gagged also. Me, I walk in there and I can't ask a question to the perpetrator. So I mean, it's difficult to say. Believe me, I'd love a voice in those, but I don't want you to misunderstand and think that it's only the accused attorneys who aren't allowed to speak, because in those proceedings, it is often down the middle. Neither party is permitted. Neither party's attorney is permitted to speak.
Yes.
I'm a university Title IX coordinator. I wanted to ask a question directly related to representation.
Sure.
So one of the questions that I get from students, I do a lot of training, and I'm an attorney, is what if one party can afford an attorney or can get an attorney for free? Would the university pay for the other party to get an attorney? And if not, is that a fair system?
I'm guessing that's probably an appropriate question for, anyone here on the panel, but I'm thinking in particular Brent, so.
Sure. And with that question of what level should attorneys be provided by the institution, you should know that there is an institution that just decided it is going to provide attorneys to each side. Stanford has just made that decision. I think it's the first college in the country to do so, which I think is remarkable. There's definitely an access to justice issue, as you correctly identify, Frank, that sometimes disproportionately parties are not able to afford representation. And the federal standard, which comes under the VIWA Section 304 that I mentioned before, actually speaks to the right to have an advisor, not the right to have an attorney. You have an advisor of your choosing. Could be your mom, could be your roommate, could be your Aunt Kathy or your professor. So sometimes students will choose, and this would go for employees as well, students will choose to have an attorney in that role. But I think that given the fact that they're not guaranteed an attorney but guaranteed an advisor, there'd be no obligation for a university to provide that service. What I hope instead is that there are sufficient pro bono and victims' rights and activist organizations on both sides that individuals can find an attorney who will work at reduced fees or no fees at all if they need them. And luckily we have organizations like VRLC and Serve Justice and FACE and Save Services that do provide that kind of equity of representation, if you will. And I hope that more attorneys who this field is getting very crowded with Title IX lawyers, right? And so hopefully that will mean also that there are more who are willing to provide pro bono services.
Let me just follow up on that real quick. One thing, just to take a little bit of a quibble, there are no organizations that represent accused students pro bono, full stop. FACE doesn't do it. I'm on the board of directors. It has a teeny tiny budget, and they just basically offer support to families and have a list of lawyers they'll send you to do these cases. Save Services, a sort of a men's rights organization that also does not provide lawyers. So victims, accusers have much more access to free lawyers, like the Victims' Rights Law Center, like Serve Justice, because it's a lot easier to get a grant from the state or local or federal government if you represent accused rape victims than it is if you represent accused rapists. So there is no organization in the country that provides pro bono representation for accused rapists, and I don't think you will ever see one. So I think it's quite inequitable. And then in terms of the who can pay, I think there's probably no statistical difference between an accuser's and an accused's ability to pay for a private lawyer.
Oh, I completely disagree with that.
Interesting.
Yeah.
How? You have data on that?
Absolutely. In having handled more than 1,000 cases, I see that there's a huge disproportion of privileged men, 1%ers, who are accused far more often than those who cannot avail themselves of legal representation.
Come on, Bernie. I don't buy that for 1 second. All right.
Name calling?
I know you. I can call you that.
So, Sandy?
So I had one observation, one question. So these advisors, they're not allowed to participate in the hearing either, correct?
Well, it depends on how you define participation, Sandy,
Well, I
right?
meant cross-examining.
No, they're not providing full adversarial representation.
Putting on witness.
Absolutely not. They're not allowed to give evidence, but they're allowed to advise their client.
So my second observation is, let's not forget that we're talking about 18-year-old kids, 19-year-old kids that are supposed to be defending themselves in a situation where they're not prepared to defend themselves in a system that doesn't seem to be very fair if you can't have, somebody who is familiar with the process. So, I mean, it's just an observation.
And I have an observation. Maybe Sandy, it's something we can take up in council. Frankly, the issue that Justin raised about no organization, if that's accurate, no organization providing representation, I would move that we talk about it in council.
All right.
Yes.
I've had a few of these cases, not nearly as many as Justin, but in my experience, the university's staff, whoever is designated to be a prosecutor, fills that role of being a prosecutor, organizes witnesses who support the victim's version of what occurred, gathers all the evidence together, and has made a presentation and has prepared it. And the student, if he has a faculty advisor, maybe, comes into the room and is confronted with all this, has really no way to prepare, to cross-examine, to present his own witnesses. And I think that institutions that I've seen that do this, it's really, these days, and I don't know about 20 years ago, but these days, it's really like a counter.
Just to offer a counterpoint to that, yes, I mean, good representation would certainly be a boon to the process, but please think about what the implications would be on the willingness of female students to report to begin with if they knew they were entering into such an adversarial process.
Just one question before we turn to, although this is kind of, a lot of this, I think, Brian, are things that you were going to address in this next phase.
Sure.
But what about discovery? In your experiences, Brent, are the accused entitled to discovery in advance of the hearing, or is discovery presented for the first time at the hearing?
Yeah, so in terms of the issue of discovery, the parties are both now entitled to it for the first time ever, based on, again, this VAWA Section 304 that I've talked to you about, that's been in place since 2014. It is not discovery in the sense that we consider discovery, but they are guaranteed by federal law the right to have access to all documents and information that will be used to inform a final judgment, and to be given that in advance. So in a college context, that's often an investigation report. It may be summary documents that include interviews or a copy of the complaint itself. And so under the federal standard, they are supposed to be getting that now in advance as an opportunity to prepare for a hearing or whatever the final determination may be. Unfortunately, most colleges are honoring that new standard in the breach, not in its written form. I would say the majority of campuses at this point are not affording that opportunity, which is making hay for folks like Justin and others to place due process or fundamental fairness at issue before the federal courts very successfully. I mean, it's astounding to me that colleges play hide the ball all the time and say things like, we won't show you your report, until after the process is done. Or my favorite, which is, you can come in and inspect the report with your attorney, but you can't have a copy. Yeah, it's insane that they operate this way, but they believe that there are federal privacy standards that require them to behave this way. And in fact, I think they're forgetting probably the most important principle of all, which is equal dignity.
Well, and
Yeah, very briefly,
on
because I also want to get to Preston and to Karen, yeah.
No, I was just going to say that you would be well advised, if you agree with that, which I think all of us do, to look, the OCR just has a brand-new resolution agreement out against Wesley College in Delaware, and one of the main issues was that the accused student was not provided the opportunity to review the documents prior to the hearing, and OCR found that a violation of Title IX.
Yeah, the important implication of that is for the first time, two decisions actually just came down from OCR where they have sided with the accused students, essentially arguing that equity rights under Title IX or due process rights under Title IX, they're not quite sure about this, have been violated by colleges. And I think that's a clear signal from OCR that the historical favoritism that colleges have been showing, in part because they thought OCR wanted them to, is not what OCR really wants.